All right, here we have Mr. Stephen Michael Bush. Thank you.
All right, guys, let's see if we can get this thing going here. I'm very animated, so I may jump off this stage, who knows. But I tell you what I may do is actually come down, and we'll see how far it works, because I move a lot when I public speak. How many of you have been in my public speaking classes before, or any of my sessions? You know I'm very, very, very energetic, so we'll see. So my name is Stephen Bush, and I have the Bush Law Group, and we represent policyholders in Virginia, North Carolina, Tennessee, Georgia, and Florida. So if you have any claims or any cases in those states, we'll be happy to help you in any way possible. I used to be a public adjuster. For many years, I was a public adjuster. I was also a contractor, and actually climbed on those roofs when I was a lot skinnier and a lot younger. My back didn't hurt me then. But now, I don't do that. But I know exactly what you go through as a public adjuster, and the fight you fight, because I did it for years. And often I have said that I don't associate much and relate to the attorneys, because even though I am an attorney, I relate more to the public adjusters because I did that for so long, and I understand your fight and your plight. So tomorrow night we are having a social at the Hilton, just right out the doors here. And we're going to be doing a networking social. We're going to have dinner for you. Max has put together some great food, and he's got some live entertainment. I think you're going to really like the entertainment. So it's going to be a really fun event. We're going to have open bar, and you're welcome to bring anyone that you want to bring. But I do ask that you RSVP, because the hotel wants to plan the food and the amount of space and things like that. So it's very easy. You're just going to go to bushlawgroup.net/RSVP. And I think it has 3 questions, but we'd love to see everyone at the social with us tomorrow night. It's the Crystal Ballroom in the Hilton, but you'll be able to find us pretty easy. Everyone's welcome, so feel free to come. Okay, so I'm here to talk about the 2021 legislative update and the new Florida laws that are coming out. I didn't pass a thing. I am not a legislator, so please do not shoot the messenger today, okay? We have a lot of information and a lot of ground to cover, and because we have a lot of information, and I'm sure you're going to have questions at the end, because some of this information is pretty bad. And I have to tell you, there was quite a bit of discussion about all of this new changes that were coming about, and I'm a founding board member of FPC, the Florida Policyholder Cooperative. So if you are a Florida public adjuster or an attorney and you work in Florida on a regular basis, you need to know about the Florida Policyholders Cooperative. It's Hillary Cassell and her group. She's put that together, and they are a political PAC that represents policyholders' interest in Tallahassee. And she goes about this a little bit differently in that she's all about protecting the policyholder. Because if we protect the policyholder, who else are we protecting? Us. All of us, right? So how many Florida public adjusters do we have in here? Okay, quite a few. All right, well, there's been a lot of changes, but fortunate because of the work of FAPIA, FPC, and FAIR, public adjusters didn't get killed too badly this year in the bills that were passed, but the one that did get killed this year was the contractors. Now, I was fortunate enough to be in a private luncheon at the Governor's Club in the library, closed door, only 6 people in the room, with Representatives Renner and Rommel. Rommel is the one who put together House Bill 76. And I'm going to tell you, he told us straight up that I'm coming for contractors, I'm coming for attorneys, and I'm coming for those public adjusters that claim run for contractors and attorneys. That's what he told us. So if you look at the bill that was actually passed, you're going to see that he was very successful in doing that. The bill almost did not pass. It got all the way to the very last day, and it passed in the evening. But what happened was, and we were hoping that it was just going to die, but the governor, Ron DeSantis, called and said, listen, you either pass insurance reform this year, or I'm going to hold you over for a special session. Now, that's what we were told. If that actually happened, I don't know. But that was the backroom talk. So don't shoot me. I'm just the messenger. The two bills that passed was House Bill 76, Senate Bill 76 and Senate Bill 1598. Both of those have passed and are on their way to the governor's desk to be signed, and both are going to go into effect on July the 1st. Restrictions on contractors. How many of you work with contractors on a regular basis? Okay. I think you should. I think all public adjusters should form some type of an alliance with some contractors, right? Because they're not allowed to adjust claims. They have their place, you have your place, and together, the two of you can work to make sure the policyholder gets fully indemnified and that they're protected. However, what they're doing now is they're trying to break up that relationship. They don't want contractors involved at all. So, House Bill 76, restrictions on contractors are prohibited from advertising in what? In any manner that would encourage, instruct, or induce a consumer to contract with a contractor or a public adjuster in making an insurance claim for property damage. All right, take a good look at that. Let it soak in for a minute. Think about what it says. They're prohibited from advertising in any manner. Door knocking, is that advertising? It is, isn't it? That's what contractors do. They're known for that, right? Flyers, door hangers, right? So when you're in a neighborhood, and as a public adjuster, I used to do this. If I had a call, I would go 4 houses one way, 4 houses one way, and then 8 houses across the street, and I would hang my public adjuster flyer, right? I could do that as a public adjuster. Now, contractors can't do that, but that's the way they teach you to keep getting these referrals. So what are they prohibited from doing? Soliciting residential property owners, offering rebates, gift cards, gifts, cash, anything in exchange for an inspection. They were doing that. They were paying these guys as much as $200 to $500 for an inspection of their roof. Not anymore. This prohibition would include, but it's not limited to, solicitation of any kind. Look at these words. Remember, what did it say a while ago? Any way, right? Any kind, any and all. Look at these words that they put in the bill. From in person, that would mean door knocking, door hangers, business cards, magnets, flyers, pamphlets, and emails. How many of you are familiar with the company that has roofclaim.com? Not anymore. Going to have to find something else, right? Can't do it. It's a $10,000 fine if you get caught, and it's per occurrence. Prohibited from offering, delivering, receiving referral fees for any services related to insurance claims. Again, these are restrictions on the contractors. We're going to get to public adjusters, but contractors and or any person acting on their behalf cannot interpret insurance policies nor offer advice as to the coverage of duties after loss. So all that, it goes back to unlicensed practice of public adjusting. That's been the law, but now they're codifying it into statute. They must provide the insured with an agreement and an itemized detailed cost of services. How many of you seen contractors where they say to be determined on the amount, or we will accept whatever the insurance company pays, et cetera, right? Not anymore. No contingency contracts for contractors. Now they've got to provide them with an agreement and an itemized detailed cost of services, scope of work. for the repairs that are to be made. They may not enter into contracts with residential property owners for roof damages without providing notice to the policyholder that they are prohibited from engaging in, basically, unlicensed practice of public adjusting, and that they cannot be involved in any way in helping them file a claim or suggest that they file a claim, all right? That's pretty bad, isn't it? That's bad for these contractors. I think it's horrible. Failure to provide the notice within 10 days, the policyholder can avoid the contract. So, if they don't provide this notice within 10 days of the date of the agreement, right? They're now 6 months into it. They didn't provide the notice. The policyholder can cancel the contract. Everybody's looking at me with blank faces. What's going on? What you thinking? Well, what did we just read? No rebates, right? Well, I think now you got a whole other contractual obligation. Yeah, this is before the roof is going on and before any money changes hands. All right, so for the purposes of 49-147, any act or anyone acting on behalf of the contractor that commits those violations are basically imputed onto the contractor. So what do they really want you to have control of is your staff, your door knocking team. They want you to have control of all of them because they're putting it back now onto the contractor. They're prohibited from solicitation of claims handling, advertising claims handling, or offering to handle claims. I know a lot of roofing sales guys online that have every bit of that in their profile. Can't do that anymore. It's a $10,000 fine. All right, so what it does not do, however, is preclude a contractor from suggesting or otherwise recommending. All right, look at those words carefully. Suggesting or recommending to a consumer that the consumer consider, very carefully, listen to the words, consider contacting their insurance company to determine if the proposed repair is covered under their insurance. So you cannot say, hey, your insurance will pay for this. This should be covered under your policy. Call your insurance company and file a claim. That's a violation. What they have to say now is that, hey, here's my estimate. Here's what needs to be done in order to repair your property. You might want to check and see if your insurance company will pay for it. That's all you can do. That's it. They've softened it up a lot, but they can only do that if they're under contract already with the policyholder, all right, for the determined amount of the estimate. Now, a contractor can explain their estimate, their scope of work, and they can do all this without being in violation of the statute. So I've heard a lot of contractors say, okay, well, based upon these last two slides, this slide and this slide, nothing's changed. So with a show of hands, how many think nothing's changed? How many of you say absolutely something's changed? Well, let me ask you this. In the beginning, because the insurance companies wanted this, I can promise you that they're going to make an example out of somebody in the beginning to try to shut it down. My recommendation is don't be the somebody that they use in the beginning to set the example, right? Right? Don't be the example. So if you have a contractor, or if you are a contractor and you have door knockers out there, if you have claims sales guys out there, and they're helping homeowners file claims, or they're talking the homeowner through the claims process, you're going to be in trouble. They're going to start turning you guys into the state right and left. Why? Because they're trying to shut this down, and they're under instructions to do that. And the other part of the statute says that, of the bill rather, that's going to become statute, is that the insurance company has to have these procedures in place to report it back to the Department of Insurance. And the Department of Insurance has to give accountability. So I think it's going to be pretty rough in the beginning. I think that based upon what I know from being in Tallahassee, that they are definitely going to be enforcing it pretty heavily up front. So public adjusters, apprentices, nor anyone acting on their behalf cannot offer a residential property owner any inducement in exchange for allowing them, or a contractor or any other person acting on their behalf, to inspect the residential property owner's roof or for making a roof damage claim. I don't think most of you are doing that. I don't see a lot of public adjusters saying, hey, let me check out your roof, and in exchange I'll give you a $100 gift card somewhere, or a $50 gift card here, or whatever the case. I don't see a lot of that. All right, wait a minute. I got a bunch of questions coming from every angle. Let's start right here. No, this is about public adjusters. This has nothing to do with carriers. This is all public adjusters. All right, back here. Exactly. I think this just tightened it up a little bit. All right. So don't go out there as part of your door hangers or part of your advertisement that says, let us inspect your roof and we're going to give you anything, because you can't do that. You're going to get in trouble. No compensation, including a referral fee, may be given or received for a roof damage claim. So what's our repetitive, recurring theme here? What's the most expensive part of a claim most of the time? The roof, right? All right, so what are they trying to eliminate? Roofs, exactly. Thank God we didn't get what was originally in the bill. How many of you heard about the ACV portion that they were trying to do? All roofs in Florida now are going to be on an ACV schedule. Remember that? Thank God that didn't get in, but what did get in to the bill is that now all carriers, not just surplus lines carriers, but all carriers can offer ACV policies, which I think is a bad deal. Very bad deal. And we tried to tell Senator Rommel, we said right there, and Hillary told him, she said, look, if you're going to do this, if you're going to make these ACV policies available, you need to have the policyholders sign off on it, just like you do the ordinance and law sections. Because, right, we all know in Florida that if you don't have ordinance and law coverage, you have to sign a waiver, right? So we were saying if you're going to sell ACV policies in Florida, then do the same thing. Make them sign the waiver so they can prove that you had the ACV. If you can't produce the waiver, your policy's automatically RCV. Didn't do it. Didn't get in. I think we know why. All right, so a violation of this section may result in a $10,000 fine per violation. So that's going to codify the unlicensed practice of public adjusting into statute, and it's going to subject those who engage in the practice to the same $10,000 fine per occurrence. Now, I don't know if you guys have been involved in any Department of Insurance or any kind of investigation from the state, but once they have one claim against you and they investigate you, they can now come in and the whole bottle of wax is now spilt, and they can check for any and everything any and everything once they get in there. It's not for that one violation. It's for everything they can find. And it could be for things that they didn't even come in for. They can find other things. All right? So you don't want that to happen. Run clean. Run straight. And you'll be okay. License and appointment requirement. All public adjusting firms and IA firms now are required to have licensure unless the licensee is a sole practitioner. So if you have a practice in Florida and you have an office, you're going to have to license the office as well as the adjusters, all right? Unless you're a sole practitioner and you're working under your own license and your own license number. But you can't have any employees, you can't have any apprentices. You really can't have anything, all right? I think that's different than someone else who's out there filing claims. So if you have a secretary, assistant, you're still a sole practitioner, in my opinion. Well, that hasn't yet to be determined. Deborah, have you heard anything about that? Yeah, I completely agree. I believe they have some claims under the Constitution. I think their constitutional rights have been violated, and some of these groups, these larger groups, these contractors groups who have a ton of money, they are already assembling. There's attorneys assembling everywhere right now, getting ready to start filing lawsuits. He just has to sign the bill, and I think the lawsuits will start dropping. Well, but the problem is a contractor can't recommend a public adjuster. Yeah, well, that's a possibility. All right, that is a possibility. No, it says no. Can't recommend. Nope. In my opinion, now, Deborah, you tell me if I'm wrong. You check me here. But I believe if you're a contractor and you say, look, the insurance company's going to have his adjuster, you should probably think about having your adjuster. You an adjuster. Is that going to violate the statute? Yeah, I agree. In the beginning, guys, and I'm bringing up the contractor stuff in particular because I know so many public adjusters work with the contractors, and this was a big portion of the legislation that was passed was dealing with contractors, because we've been told in the backroom talk is that next year everybody's going to be safe next year. They're not coming after us too hard next year. There'll be some things here, some things there. Whether or not that happens, we'll see. But the following year, in 2023, it's going to be bad. They're really gunning for everybody in 2023, and they're setting it up for 2023. So we shall see, but I don't know. That's right. It's awful. All right, Adam, what you got?
Referring it over to public adjusters, after reading the bill, doesn't mention anything. I know we've worked with attorneys also, but nothing pointed directly at roofers or contractors or, law mitigation or, attorneys directly, even though hand on hand you're talking public adjusters and attorneys for, people, especially attorneys who handle cases pre-suit. Is there any prohibition stopping the referrals to attorneys directly to attorneys?
Well, here's what it says. It says that a contractor cannot encourage, instruct, and whatever the other one was. I forgot. There was three. Encourage, instruct, and something else. Induce. Thank you. A policyholder to file a claim, right? Can't do it. So would telling a policyholder to contact an attorney be it induce, instruct, or encourage?
My view of that is your attorney or potential attorney is going to be the one who says, hey, you may have coverage here, you may not have coverage here. So, the end result of something telling somebody to potentially file a claim, or you should have coverage after looking at your policy here, but it comes directly from the roofer. So, in my theory, kind of bypasses that statutory provision there because at the end result, it's the attorney who's going to be letting you know whether it's plausible to file a claim to run with the claim because you have the coverage, you don't have the coverage, or you have limited water damage, not worth it, whatever the case may be. But it's not that. It's not the roofing company saying, hey, you should file a claim. It's like, hey, ask an attorney. They may tell you whether it's worth filing a claim.
Well, I can tell you now, every desk adjuster that works Florida right now has been instructed. The first question you asked is, are you working with a contractor? Are you working with a public adjuster? Did they tell you to file this claim? That's going to be the first question asked. And then second question is, well, who are they? What's their name? What company do they work for? That's the way this is going to go down in the beginning. It's going to go down that way. I mean, listen, I was there. I was there with the guy that wrote the bill. I was there when we were begging him to revise the bill. And some of the things we were able to get him to change. And some of the things he just told us to either take it or it was going to get worse. That's what he told us. You either take what I'm giving you or you're not going to like what I give you. One of the two. So, I mean, it was just bad. So they're looking in the beginning to shut some of this down. And this is the way that they think they can do it right now. So let's get back to this licensing and appointment requirement. If you have a branch office, these are the requirements if you have a branch. So my suggestion is after July the 1st, call the state and find out what you really need to be doing. All right? Let them tell you and make sure you get it in what? Writing. Because if you don't have it in writing, yeah, you're screwed, right? Your word against them. Solicitation. This was pretty much already the same anyway. You guys can, as a public adjuster, you can solicitate between certain hours. I think are these the same hours or did they revise them? It used to be 8 to 8? Okay. It's 9 to 8 now. So they gave you an extra hour to get out there and hump. You can thank FAPIA for this. FAPIA was big and knocking a lot of this public adjuster stuff out. And they were really big in expanding it to where, and I know we kind of breezed through it pretty quickly, but now everyone that's at that the insurance company sends out has to be licensed, and they have to tell you they're licensed. They have to give you their license number. That's better than it was, right? Because how many times do they send someone out and they weren't even a licensed adjuster in the state of Florida? It happened all the time, right? All right, we can't do that now. Under your public adjuster's contract, they can cancel without penalty within 10 days after the date in which the contract is executed. And you've got to put this language on your contracts now. And it has to be an 18-point bold type. $18, come on. Who do they think's looking at this stuff, right? 18-point? Public adjuster must provide to the insured a written estimate of the loss to assist in the submission of a proof of loss or any other claim. All right, or any other claim for payment of insurance proceeds within 60 days after the date of the contract. So how many of you public adjusters are not writing estimates in the beginning? That was a setup because I knew nobody was going to raise their hand. but a lot of them don't. A lot of public adjusters don't write estimates. They get the contractor to do it, or they wait for the carrier's estimate, and then they decide to put one together. Can't do that anymore. Not in Florida. You're required now to give the policyholder a scope within 60 days after the date of the contract. Now, let's take this one step further. Philip Sanoff has a case of yours in litigation, and Deborah's the defense attorney, and Philip files the lawsuit. Deborah, being sharp and smart and detail-oriented as she is, she looked and she says, well, you know what? This public adjuster's estimate is in December. And this policyholder signed the contract in March of the same year. So what's she going to do? What's she going to do? She's going to go after it, right? When's she going to go after it? Knowing Deborah, she's going to go after it in discovery, and then she's going to go after it in deposition. Don't put yourself in that position to have to answer for that. Sure. Exactly. Well, a written estimate. Well, how are you going to give them an estimate? That's not an estimate. An estimate is tied to money and scope. Yeah. Listen, I love that public adjusters are always trying to poke holes in everything. I got that. But don't overthink it, all right? Don't try to run it around circles around it. That's how you get in trouble, all right? Don't overthink it. Yeah, because before I think it was, 3 days? And then if it was a hurricane, it was 5 days, right? It was 3 and 5. Right. So this give you a little bit more time. Again, this was FAPIA that helped put this language in, so congrats to them. But you're talking about the estimate, right? What does it have to be? Well, there you go. They put it in there for you. So it must include an itemized per unit estimate of the repairs, an itemized information on equipment, materials, labor, supplies in accordance with accepted industry standards. So is Xactimate accepted industry standards? So how come the carrier doesn't ever want to pay Xactimate pricing? Well, okay. They're supposed to go hand in hand, aren't they? In some instances, but they never do. So you got to retain these estimates now for at least 5 years, and you got to make them available. Do you know how many times I've had public adjusters call me and they say, hey, I got this client, I gave them a scope, insurance company didn't pay, they got mad, so now they went and they hired an attorney, and now the attorney wants my estimate. Do I have to give it to him? I'm like, well, why not? All right, so you didn't keep the client. That's your fault. All right, that's shame on you. You should give him the scope. Now, you don't have a choice. You got to give it to him. That's the only thing that was in the statute. You must retain the estimate for at least 5 years. Right, but if you're keeping good business records, you ought to be keeping them anyway. You ought to be keeping everything together. One more time. In Texas? Well, in Florida, you just have to keep the estimate. You don't have to keep anything else. But it is a good business practice, and I agree with you 1,000% that you keep everything and you keep it all together. But the only thing that's in the statute now that's required is the scope. That was the only thing that they have in the statute. And the 15, I know what yes. Yes. That's right. That's right. For today's, let's clarify. So for today's purposes, we're talking about these two bills that were passed, okay? Everything else still's in play if it's already there, but right now we're focused on just these two. All right, so an insurer shall maintain a record or a log of each adjuster who communicates with the policyholder. Thank God. Thank God, because you know how many times we had a case not too long ago, and we had a corporate rep deposition, and come to find out there were 4 other adjusters that had been out there we didn't even know about. Homeowner didn't even know they were there. They came when the homeowner wasn't there. We didn't even know about it until the corporate rep deposition. Now they have to provide you with a log of them, and they have to provide the list of the adjusters to the insured office or department. That's the Office of Financial Services and Department of Insurance. Upon anybody's request, upon their request. So we're going to change that up a little bit, and in my interrogatories, because we file them with a complaint, like most policyholder attorneys do, I'm going to start asking for the log. Give me the log. I want to know. So when the insurer provides a preliminary or partial estimate of the damage to the insurer shall include with the estimate the following statement in 12-point bold type uppercase. All right, look at this and tell me what the hell? So this estimate represents our current evaluation of the covered damages to your insured property and may be revised as we continue to evaluate your claim. If you have any questions, concerns, or additional information regarding your claim, we encourage you to contact us. As a defense attorney, Adam, that's on every scope, but you don't agree with the scope and you filed a lawsuit. What's the first question they're going to ask the policyholder? All right, now all right, what's your name? Renee, finally good to meet you. Talked to you 100 times on the phone. All right, so Renee, now help me. All right, because we're trying to help these guys, right? We want them to help us when it gets to us. So how do we, as public adjusters, prevent this from happening so that when it does get to litigation, we don't get asked that question? All right, perfect. So that's good advice. That's good information right there. So now if they're going to pay a partial payment, they have to provide a notice on the estimate that says we're continuing to evaluate your claim involving your insured property and may issue additional payments. If you have any questions, concerns, or additional information regarding your claim, we encourage you to contact us because you are in good hands. And like a good neighbor, we care about you, right? All right, be looking for those. They're coming, but I think it does trigger a response back from the public adjuster. Candace mentioned it earlier, and I just want to kind of reiterate this. So many times we get claims or files from public adjusters, and the carrier has written 3-4 letters making these requests, and the public adjuster never responded back, never back. Guys, don't do that. Now listen, I know you're hustling. When I was out there, I was working out of my car. I mean, imagine most of you do. I had a little printer set up in the trunk. All my files were in there. I had a big file box. I worked out in my car. A lot of times I would park at a Publix or a Target or Walmart parking lot out in the far end, and I would work, answer calls, and do whatever I could do. So I was busy, and I wasn't in the office, because if I was in the office, I wasn't making money. I was making money when I was out in the street. So you can't do that anymore. You're going to have to figure out a way to respond back to these carriers when they send you information. And a lot of times they don't send them to the public adjuster. They send them to the homeowner. So you have to follow up with the homeowner. Did you get any correspondence from the insurance company? Save it. I need it. Send it to me. And then you have to respond back to it as their representative. Be sure and do that. So 90 days after an insurer receives notice of initial reopened or supplemental property damage claim, the insurer shall pay or deny the claim or portion of the claim. This was, help me here, this was not in statute before in Florida. It was, right. So now what we have, I think what you say they had to pay it within 90 days unless there were circumstances beyond the control of the insurance company or they were still evaluating the claim. Isn't that what it said? Okay. So now they've taken all that off and they said, no, you can thank Hillary Cassell for this because she fought like hell with Rommel and Renner to get this in. All right. That was a good move. Right. Well, I think now it establishes that you have a dispute and the policyholder can file suit. That's right. That's right. All right. So notice of a claim, a reopened claim, a claim that an insurer has previously closed but has been reopened upon the insurer's request for additional costs less than damage previously provided to the insurer. Either means by either the scope or the price, whichever one is in dispute. All right. So this is now the definition of a reopened claim. This is the definition of a supplemental claim. It means a claim for additional loss or damage. All right. So look at the difference. All right. It was closed, but it's been reopened. It means a claim for additional loss or damage from the same peril which the insurer has previously adjusted or for which costs have been incurred while completing repairs or replacement pursuant to an open claim for which timely notice was previously provided to the insurer. So we already had those definitions. We pretty much knew that already, right? But now those definitions are in statute in Florida. Crazy. You don't get to make the claim. All right, so again, Hillary, at our luncheon, initially they had all claims in Florida were now, you had to file them within 2 years, bottom line. Hillary explained to them the difference between a supplemental and a reopened claim, and that you can't do that within 2 years because now what you're doing is you say you got to file a claim, You got to supplement a claim, or you got to reopen a claim, which all happens after the claim process has taken place, right? You want it done within 2 years. It's impossible. It's not going to happen. And so he got it. He got the light bulb, and he said, okay, so new time frames in Florida, no longer 3 years, now 2, and you do have now 3 years for your supplemental and your reopens, all right? Claim, yes. Within the 2-year time frame, that's right. Then supplementals are 3 years, correct. All right. Keep me straight, guys. So it means hidden damages that were previously unknown but associated with the same peril. All right, so for claims resulting from hurricanes, tornadoes, windstorms, or other weather-related events, the date of loss is now going to be set. Because the dates of loss were all over the place, right? No longer is that going to become a question. The dates of loss are now going to be set. They're going to be set by the National Oceanic and Atmospheric Administration. So as a condition precedent to filing suit, we now have this wonderful 10-day notice requirement. That's a big uproar right now among the plaintiffs' bar, is this 10-day notice requirement. Part of the reason why is because the statute also requires that the insurance company have procedures in place to respond to the 10-day notice requirement. Do they have that in Texas? Okay, well, wow. That's what I was thinking too. 10 days isn't so bad. But again, the notice of intent cannot be filed until after the carrier has made a coverage determination. And the notice must contain specific information as outlined in the statute. So here's my problem is how many times do you get files and they say, we're still investigating the claim? We're still investigating the claim. So have you made a coverage determination or not? So that's going to become the gray area to me, and that's going to be the issue that's going to be litigated by attorneys to prevent motions to dismiss, all right? And this is what I was talking about. The statute now requires that the insurers have procedures in place for the prompt investigation, review, and evaluation of pre-suit notices. So they're going to have a whole department, in my opinion, and that's all they're going to do. So when they get a pre-suit notice, they're going to kick out a letter that's going to be a form letter, and here's what it's for. They have to respond either by accepting coverage, continuing to deny coverage, or asserting the right to reinspect the damaged property. I think that is Texas, isn't it? Okay. Yeah. It's within the 10 days. Right, and it was my understanding that because of that Texas law is all changing to kind of comply with what Florida's put in place. And the reason why Florida put it in place was because Texas suggested it. So I think there's a lot of that. Well, we actually have a new form that we have to use. Its notice must contain specific information that's outlined in the statute. And it's pretty detailed from what I understand. They haven't compiled it all yet, but we're going to find out sooner or later, right? So once you send the 10-day notice in, they can respond by telling you they want to inspect, they're providing coverage, or no, they're going to stick to their coverage decision. And if they assert the right to reinspect, they must do it and let you know within 10 days. But see, this is what I don't like about this. If they assert the right to reinspect, the insurer must provide a response by email. But it doesn't go far enough to me. It should say that they have to do the reinspection within a certain period of time. Now it just says, no, we want to reinspect. Okay, when? Well, sometime next year. All right, so I have a problem with that. So upon the insurer's continued denial of coverage, the policyholder may file suit without an additional notice. But here's the problem with this notice requirement that we have in Florida. If the notice of intent to file a lawsuit alleges any act or omission on the part of the insurer other than the denial, the insurer must either offer to settle or participate in appraisal or alternative dispute resolution. All right. Lawsuits to courts. That's exactly right. That's exactly right. But see here, so let's break this down just a little bit. Max is telling me that I don't have much time and I have some more stuff to do. But I want to break this down for you because I want you to understand where they're going with this and what they're trying to do, all right? Now, like Renee said, lots of litigation is going to go on after this thing is signed. And we'll see how it all shakes out. But for right now, we just need to read it for what it is and for what it says, all right? And then we'll figure out what it actually means later. All right, but look. So if the notice of intent to file suit, if it what? Alleges any act or omission on the part of the insurer. Philip, if you know that the carrier can then invoke appraisal or force you to alternative dispute resolution, are you going to allege any act or omission on the part of the insurer? So what happens when you get into litigation and they say, hey, well, you didn't tell us that in the pre-suit notice. You didn't give us that in the pre-suit notice. So here's my response. I've already thought about this. My response is, I discovered it after. This was new information that I discovered after I sent in the pre-suit notice, right? Because in litigation, as information and through discovery, we can present it, right? So that... That's an act or omission. That's right. That's right. So how many appraisers in here? How many appraisers work in Florida? All right. We had less hands. You better get your appraisal license up to date in Florida because it's coming. Appraisal is going to be huge in Florida, in my opinion. Well, you have to have the certificate thing. The what is it? Not license, the appraisal license. The certification. You have to have that certification. Yeah. All right, so the alternative dispute resolution has not been concluded within 90 days after the 10-day notice of intent. The claimant, which I should have changed out to policyholder to make it a little easier to read, but the policyholder may file suit without further notice. So mediators are going to become very busy, I think, in Florida. If the notice of intent is not filed prior to suit being filed, the court must dismiss the suit with prejudice and no attorney fees can be paid. No attorney fees can be paid for any work pre-suit. All right, so how did this change the attorney fee provision? Well, now when we give the pre-suit notice, or we have to give a pre-suit settlement offer in the notice, all right? If the disputed amount is less than 20% of the disputed amount that you recover, each party pays its own fees and costs, and the plaintiff may not be awarded any attorney's fees. But if it is at least 20% but less than 50% of the disputed amount, the insurer pays the plaintiff's attorneys and costs under the fee statute equal to the percentage of the disputed amount obtained times the total attorney's fees and costs. So if I have a claim and I got 30%, if I settled it for 30% of what my pre-suit notice was, I get 30% of my total fees and costs. That's basically the way it's going to work. So what's going to happen to attorneys filing suit? What are they going to do now? What's it driving down? Exactly. Yeah, but I think it's going to really drive down the pre-suit settlement offers that attorneys are going to be putting out, because otherwise it's going to come out of the indemnity portion, right? So it's really driving the numbers down. That's what this was designed to do, was to drive those numbers down. So the indemnity portion is going to be driven down. The attorney's fees are going to be driven down. Everything's coming down now, and that's what they were trying to do. But the good news is if we get at least greater than 50% of the disputed amount, the insurer is going to pay the entire reasonable attorney's fee. So I had John over here, who is my COO, go through and pull the dollar amounts of what we demanded in our civil remedy notice, our cure amounts, versus what we've actually been settling. And thank God we're between 75 and 80%. So in my firm, it's going to change a little, but it's not going to change much, because we're getting good settlements based upon the scopes of work that we're using in suit. But I can tell you that a lot of attorneys are not going to be in a very good position here, and they're going to be forced to drive those numbers down. And they're all right, guys, I have 1 minute, so we're about there. So when the insurer sends an adjuster to inspect the loss, they must also include the adjuster's name and license number. We needed that. All communications by any adjuster must also include the adjuster's name and license number. You can thank FAPIA, you can thank FAIR for that. All of these came from their efforts. The insured may request a log with the identifying information of each adjuster that's worked on the claim upon their request, and the insurers are now required to have a statement that lets policyholders know if further evaluation may result in any additional payment. We've talked about that, and I think we've answered a lot of questions while we're there. My time is up. Thank you, Sean. Thank you, Cal. Thank you, everybody. That was fast. All right, I think we're going to be taking questions. If anybody wants to talk more about this, I'm welcome to do that. They're going to tell you where to come, and I'll go over there right now.
Yep. Down in the yacht room. So, Stephen, if you'll go down to the yacht room, and anybody wants to have some questions down there, it's down on the first floor. One of the breakout rooms down there, the yacht room. So, thank you, Stephen. Next, we're going to have... couple announcements. We're going to have Renee Sigmund with Merlin Law Group up next, and then we'll have David Sawyer with McLeod, Alexander, Powell, and Atfel speaking about TWIA policies after that. Tomorrow we're going to start at 9 a.m. instead of 10 a.m., so if everybody can get here on time at 9 a.m. tomorrow. Thank you all for working with us. I know we had main stage speakers and some breakout sessions. We kind of consolidated all that, and we're trying to get everybody on the main stage. Just so it goes through. I think it'll be a little bit smoother tomorrow, but we're going to go into Renee, and then we'll have David Sawyer, and then we have 2 other speakers today after that. And then tomorrow, everything will be here on the main stage. Thank you.